Appeals from the decisions of the magistrates' courts to the Supreme Court are pivotal in the administration of justice. The knowledge that if a person is dissatisfied with the decision of a magistrate, he or she can appeal to a higher court inspires confidence in the justice system and the rule of law. It is therefore very important that the general public has access to an appeal process that is simple, cost-effective, and user-friendly. To this end, the Jurist Project has partnered with the Supreme Court of Belize in revising the Inferior Court Appeals rules. This is an initiative which started under my predecessor, Honorable Chief Justice Kenneth Benjamin, in 2019, working along with Jurist, the Judicial Reform and Institutional Strengthening Project of Canada, to improve the efficiency with which the appeal process from the Magistrates' Court to the Supreme Court takes place. The Magistrates' Courts in Belize bear the bulk of judicial work, as magistrates deal with the vast majority of matters that are brought before our judicial system on a daily basis. To that end, the process by which appeals from magistrates' courts to the Supreme Court are lodged, filed, and heard are very important steps in the administration of justice. In the past, these steps in the appeal process were frequently attended by significant delay due to a multitude of challenges, and as the old adage goes, justice delayed is justice denied. Therefore, jurists working together with the former Chief Justice identified the revision of the Inferior Court Appeal rules governing the appeals process as a priority. In executing this goal, the Jurist Project, in conjunction with the Supreme Court of Belize, retained the consulting firm of PwC to carry out a comprehensive assessment, evaluation, and revision of the Inferior Court Appeal rules. This process included consultation with key stakeholders, including Supreme Court judges, magistrates, the Bar Association, the CEO of the Colby Foundation, in an effort to have input from those who are directly involved with the appellate process. The rules as they existed prior to this exercise were cumbersome and antiquated, written in archaic language which made it difficult for court users to understand. After these consultations were completed, the recommendations made by key stakeholders were collated and formed the basis on which the amendments to the rules were made. I therefore wish to thank the Jurist Project under the stalwart leadership of Mrs. Gloria Richards Johnson for assisting us with this important initiative. In May 2021, a training exercise was held virtually involving magistrates and other stakeholders in an effort to provide sensitization to the revised ICA rules. It is hoped that these revised rules will lead to a more efficient and effective appeal process for all court users. One of the most important changes brought about by this revision is the procedure under Section 9 of the Inferior Court Appeal Regulations. Under this new rule, if 1 month has passed after the appellant has filed his appeal and has satisfied the requirements of Rule 5 by paying a bond, and if the magistrate in a criminal case has failed to draw up a formal conviction or order, or in a civil case has failed to draw up a statement of reasons for decision, the appellant now has the right to apply without notice on affidavit to a judge of the Supreme Court in chambers for an order directing the magistrate to draw up a formal conviction or order, or in a civil case, provide a statement of reasons for decision. Sensitization exercises and public service announcements on the new rules will be initiated and prepared in an effort to make the general public aware of these important changes. It is hoped that these revised inferior appeal rules will serve as an important tool which will improve access to justice to all Belizeans.